This is Duke University.
Thank you. We're really glad that you are enjoying your lunch and enjoying the topic so far, but I want to go ahead and introduce our keynote speaker, Professor John V. Orth. Professor Orth is the William Rand Keenan Jr. Professor of Law at UNC School of Law, and he is a renowned 11th Amendment scholar and has had his publications have been cited by federal and state courts, including the North Carolina Supreme Court and the United States Supreme Court. And today, while we are all enjoying our lunch, he will be discussing his paper, which is State Debts and Federal Jurisdiction. So thank you very much, Mr. Orth, or Professor Orth, for being here.
Thank you all. It's lovely to be here, and I will try to live up to the standard which was set this morning, which will be difficult. I don't have the storytelling ability of a couple of our speakers, including my former dean, who always manages to entertain and inform, I'm glad to add. Thank you all, again, seriously. When I was thinking about this talk, I always like to pick out an epigraph to get me started. And so I looked back, actually, in a book I had written 25 years ago about the 11th Amendment, and I found the sentence, "For dryness and technicality, no subject can rival public finance, except perhaps federal jurisdiction." And the challenge of trying to talk about the two of them and keep the audience awake was one that I found daunting. But I'll do my best, and if I live up again to the standard this morning, I will be able to keep you awake, if not laughing. It is perhaps fitting to begin a paper on sovereign debtors and their creditors with Ebenezer Scrooge, a squeezing, wrenching, grasping, scraping, clutching, covetous old sinner. On a certain Christmas Eve in the early 1840s, the miser was visited by the ghost of his former business partner, Jacob Marley, who was dragging a chain made of cash boxes, keys, padlocks, ledgers, deeds, and heavy purses wrought in steel. Hoping to help Scrooge free himself from similar bondage, Marley announced that he had arranged for Scrooge to be haunted by 3 spirits. Although the old sinner fell asleep, well, after midnight, he was awakened by the sound of midnight chimes. At first, Scrooge feared that he had slept through a day on which the sun had failed to rise, and that his time-sensitive securities had become worthless. When he realized that the city was not gripped by panic, and that it was still the night of the same day, he heaved a great sigh of relief. Quote, "Because 3 days after sight of this first of exchange, pay to Mr. Ebenezer Scrooge or his order," and so forth, would have become a mere United States security. Close quote. It's appropriate to talk about Charles Dickens, by the way. We just celebrated the 200th anniversary of his birth on Tuesday. I also might add that on a long plane trip to Australia recently, I finally got around to reading Martin Chuzzlewit, and I was interested to notice that in Martin Chuzzlewit there is also jibes about American states repudiating their debts. This was obviously something on Dickens' mind in the late 1830s, early 1840s. It's mentioned not just in the Christmas Carol, but in Martin Chuzzlewit and also in Dickens' travel log, American Notes. That American debt had become a byword for worthlessness was due to the reckless financiering that ended in the Panic of 1837 and the ensuing default by a number of American states, what we today would recognize as a true United States security, a treasury bill or note backed by the full faith and credit of the federal government, had not become worthless. Indeed, after 1835, when the federal government paid off the first national debt in full, it no longer existed. Scrooge, and many Englishmen with him, had failed to understand the structure of American government and public finance, and had confused Pennsylvania and other state bonds with federal obligations. Just as the introduction of the euro in 1999 led investors to believe that the shared currency made the debts of Europe's peripheral economies just as safe as German bunts, so English investors 160 years earlier had mispriced the various American state debts. There are no euro bonds yet, so a modern equivalent of Scrooge's metaphor would be as if Scrooge had called Greek bonds, quote, a mere European security, likening junk to what would presumably be, if it existed, a AAA-rated obligation. I wrote this a few weeks ago, so I'm not sure that would be true anymore, given the downgrades by the rating agencies of some of the countries that would be backing such a bond. State bonds, American state bonds, are not fiat money, as economists use that term, but they share this characteristic with unsecured paper currency. They depend for their legal value on the judicial power to enforce them. Would American courts enforce the bonds of the defaulting American states? That was the question English investors asked their lawyers. State courts were an unpromising venue because of the recognized power of states to invoke sovereign immunity and close their own courts to suitors. Ironically, Mississippi, one of the indebted states, did allow suits against itself, and a case was duly brought and won. But the judgment went unsatisfied, and one of the judges was defeated at the next election, Mississippi being the first American state to provide for election of all its state judges. Whether federal courts would be open depended on the 11th Amendment to the United States Constitution, adopted in 1795 to overturn an earlier Supreme Court decision holding that federal courts had jurisdiction over a suit to collect a state debt brought by a citizen of another state. The amendment was adopted amid fear that domestic and foreign creditors could invoke federal jurisdiction to enforce state obligations. The 11th Amendment neatly eliminated that risk. Quote, "The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state," and then added for good measure, "or by citizens or subjects of any foreign state," close quote. Bond-holding British subjects appeared to be shut out. Viewed through the gimlet eye of a litigator, however, the terms of the amendment suggested interesting possibilities. While it closed the federal courthouse door to suits against states by two classes of plaintiffs, citizens of a state other than the defendant state and citizens or subjects of foreign states, that did not exhaust the universe of potential suitors. The obvious lacuna in the amendment was suit by a citizen of the debtor state. If citizens could use the federal courts to collect from their own state, it would establish a market for the bonds and give foreign bondholders leverage in negotiations with the debtor state. This loophole was closed by a Supreme Court decision that recognized a federal right to state sovereign immunity in such a case. But not until 1890, when another wave of state defaults after the Civil War and the Panic of 1873 generated the mushroom growth of 11th Amendment jurisprudence. Another possibility was suit by a foreign state as opposed to its citizens or subjects. In 1844, the year after the publication of Dickens' Christmas Carol, the prominent Massachusetts lawyer Benjamin Curtis, later United States Supreme Court Justice, acting on behalf of Baring Brothers, published an anonymous article in the influential North American Review suggesting just such a strategy. Parenthetically, John Marshall had pointed the way in dicta more than 20 years earlier. Sovereigns have always taken an interest in the security of their citizens' foreign investments, sometimes forcibly. Sending the gunboats was out of the question in this case, but sending the lawyers might be possible. This suggestion, too, was acted upon, but not for another 100 years, when in 1934 the Principality of Monaco sued Mississippi in the Supreme Court on its defaulted 1830s bonds, with no greater success than in the case of the in-state plaintiff. Yet another possibility was assignment to an American state as opposed to its citizens for collection. Again, parenthetically, John Marshall had signposted the way. This was tried, also many years later, but met with only mixed success. The one surefire winner would have been suit by the United States government. Whether efforts were made in this direction in the 1840s is unknown. There might have been reason to hope. The reputational damage to American credit by the state defaults affected even the federal fisc, which was denied the possibility of a foreign loan in 1842. Not a dollar, quote unquote, said Baron Rothschild to the Treasury agent sent to inquire about a loan. Political constraints probably made federal action infeasible. And I might mention that contagion was not unknown, that is, the concept of contagion, although the word was unknown. Again, after I wrote this, I discovered that Charles Dickens discusses it in the American Notes, again, berating Americans for defaulting. It's a quote from American Notes. Another prominent feature of the American character is the love of smart dealing, he puts that in quotation marks, which gills over many a swindle and gross breach of trust. It has not been without its retributive operation, for this smartness has done more in a few years to impair the public credit and to cripple public resources than dull honesty, however rash, would have effected in a century. I recollect remarking on the bad effects such gross defects must have when they exploded in generating a want of confidence abroad and discouraging foreign investment, close quote. Now, if he just said foreign direct investment and written it today, he would call it FDI, foreign direct investment, discouraged by these repudiations. Coming back now to the litigation strategies. It was also possible to approach the problem from the other end, so to speak. Rather than trying to find the right plaintiff, why not try a different defendant? Why not sue a state officer, say the state auditor, to compel payment rather than sue the state itself? The Supreme Court under Marshall had allowed just such a strategy in a suit by the Bank of the United States to recover an unconstitutional state tax collected on one of its branches. Quote, "In all cases where jurisdiction depends on the party," said the Chief Justice, "it is the party named in the record. A state officer is not a state. A suit against a state officer is therefore not a suit against a state. Quod erat demonstrandum." Years later, bondholders tried this route around the 11th Amendment, at first with promising results. But finally, this too turned out to be a dead end. However many of these legal strategies the state creditors considered in the 1840s, the one thing they did not do was to sue the state in federal court, leaving the exact bearing of the 11th Amendment on American state debt undetermined for decades. In fact, leaving open the question to what extent state debts were properly sovereign debts at all, assuming that is that a defining characteristic of sovereign debts is their uncollectability by ordinary legal means. In the 1840s, the creditor's legal situation was not unpromising. John Marshall, as we have seen, showed no enthusiasm for the 11th Amendment, and Roger Taney had never had to take a position on the amendment during his long Chief Justiceship. Despite their many differences, both men were firm believers in the reach of federal jurisdiction. Of course, there are many reasons aggrieved parties decide not to litigate, other than doubts about jurisdiction, the cost in time and money relative to the likelihood of recovery, their lawyer's skill, or lack thereof, in devising plausible legal arguments, and the chance for an acceptable settlement. In the case of the state creditors in the 1840s, it seems to have been the prospect of settlements. Many of the antebellum state debts were at least partially redeemed, the famous haircut that, of course, we now hear about. This wasn't simply private sector involvement. There was no public sector involvement at this time, so you didn't need the acronym PSI, which is now cast about. When the next wave of American sovereign defaults hit the capital markets in the 1880s, the disappointed bondholders did launch a vigorous campaign of litigation, perhaps because the prospect of settlement seemed remote under the circumstances. The result was scant recovery and a remarkable extension of 11th Amendment immunity, important parts of which survived the later revanche of federal power, indeed survive to this day. By 1890, as indicated earlier, presidents had accumulated barring suits to collect state debts against state officers, against states by other states, and against states by their own citizen. The rejection of suits by foreign sovereigns had to wait several more decades. When, 25 years ago, I tried to make sense of this sudden efflorescence of 11th Amendment jurisprudence, I became convinced that the political realities of post-Reconstruction America were more important than legal analysis. Or, to paraphrase Justice Holmes, experience rather than logic was the life of the 11th Amendment. It is the common coin of American constitutional history that Supreme Court justices in the late 19th century were unsurpassed in their zeal for freedom of contract and the protection of property. Repudiation, I thought, must have stunk in their nostrils. The cases in which the 11th Amendment was stretched to prevent suits against states all involved suits against states of the old Confederacy, principally Louisiana and North Carolina. And I should emphasize, these are not Confederate war debts, nor debts issued by states in secession to support their war effort. Those, of course, were declared void. They shall be construed illegal and void by the 14th Amendment. These were debts which were incurred either before the Civil War or after Reconstruction, or after the end of the Civil War. It was often by Reconstruction governments, but not by secessionist governments. By the time the litigation commenced, Reconstruction was over. The South had recovered home rule, that is, rule by the indigenous white male population, and the U.S. Army had been sent back to barracks. Just as the newly freed slaves were abandoned by the President and the Congress after Reconstruction, so perforce the bondholders were also abandoned by federal courts. Investors in Southern bonds were abandoned for the same reason. As the Attorney General of Louisiana candidly pointed out to the court in 1890, and this is from the state's brief, quote, "The solemn obligation of a government arising on its own acknowledged bond would not be enhanced by a judgment rendered on such a bond. If it either could not or would not make provision for paying the bond, it is probable that it could not or would not make provision for satisfying the judgment," close quote. Actually, the Attorney General of Louisiana said that to the justices of the Supreme Court in this case. By the way, I was reminded when I read this of the proposal in what I understand to be the current proposed treaty for the Eurozone, that the European Court of Justice is supposed to invalidate budgets that go over the prescribed limit. It boggles my mind how they're going to do that, other than just declaring the whole Budget Act unconstitutional and void, I guess, and sending it back to the politicians. Otherwise, they're going to have to be deciding how much for education, how much for this, how much for that. I mean, it's one thing to judicialize problems, but I can't imagine judicializing the budget of an entire country. Anyway, without the backing of the political branches, the courts, this is the Supreme Court and other federal courts, could not expect their judgments to be satisfied. The difficulty with my simple solution was that one state of the old Confederacy, and that arguably the most important, Virginia, was denied the shelter of the amendment. Study of the cases, however, convinced me that the difference resulted from a unique provision included in the covenants of the Virginia bonds, rather than in any inherent difference in Virginia's sovereign immunity. The coupons represented the periodic interest payments and were made, quote, receivable at and after maturity for all taxes, debts, dues, and demands of the state, close quote. Again, John Marshall provided the clue. In an early case raising an 11th Amendment claim, Marshall had asked the following question. Were a state to lay an unconstitutional duty on exports to collect the money and place it in her treasury, could the citizen who paid it maintain a suit in this court against such a state to recover back the money? This is just a rhetorical question, yes. And then he answers his own question with the dubious, perhaps not. But then he says, suppose a citizen to refuse to pay the export duty and a suit to be instituted for the purpose of compelling him to pay it. He pleads the Constitution of the United States in bar of the action, notwithstanding which the trial court gives judgment against him. This would be a case arising under the Constitution. In other words, a justiciable case. As applied to the Virginia coupons, this suggested a different legal strategy. Rather than sue the state or its officers to compel payment, a bondholder could tender matured coupons in satisfaction of state taxes. To avoid its solemn obligation, the state would then have to sue the taxpayer for taxes due and unpaid. Such a suit was quite obviously not a suit against a state, and a judicial decision that the taxes had been legally discharged would not require the court to order the state to make any provision for satisfying the judgment. Tender of payment by a debtor at a reasonable time and place and in a reasonable manner is sufficient to satisfy a debt or obligation, whether the creditor accepts the payment or not. In this case, the court's judgment would be self-executing. Taxes are paid when a court of competent jurisdiction says they are. Ipse dixit. This strategy was tried, and after much litigation, finally succeeded. There was also another class of government debt that was not exempted from federal jurisdiction. Cities and counties in the Midwest and West had issued bonds or pledged their credit to encourage railroad construction. In the same year that the southern states, except Virginia, got their quittance, the Supreme Court held that municipal corporations were not alter egos of the state and were therefore denied the shelter of the 11th Amendment. Quoting John Marshall, the court smugly announced, in all cases where jurisdiction depends on the party, it is the party named in the record. Cities and counties are not states, despite the fact that they derive all their powers, including the power to borrow, from the state. This time, the political branches showed their resolve to back up the courts. Ulysses Grant, war hero and president, permitted the publication of a letter stating that he would not hesitate to use force if necessary to see that county debts were honored. In modern terminology, the municipal debt is not a sovereign debt. It is sub-sovereign, which is only another way of saying that the legal means are available to enforce payment. Today, of course, the Federal Bankruptcy Code offers a mechanism for ordinary municipal defaults. As the problem of southern state bonds receded into the past, the Supreme Court began the slow process of withdrawing from a couple of its more extreme 11th Amendment positions. In 1904, a suit by one state against another, and that against a southern state, in fact, against North Carolina, South Dakota versus North Carolina, to collect on defaulted bonds was allowed. In 1908, the most significant retrenchment occurred. Distinguishing several of the bond cases, the court held that the 11th Amendment did not bar suits against a state officer to prevent violation of the federal Constitution. While finding that unconstitutional state action was threatened, the court nonetheless held that the officers through whom the state acted could not assert the state's sovereign immunity. By attempting to enforce an unconstitutional statute, he is, quote, stripped of his official or representative character and is subjected in his person to the consequences of his individual conduct, close quote. You recognize as ex parte Young if you're a federal jurisdiction student. As the Supreme Court itself later acknowledged, this holding had the ironical result that a state officer's conduct is state action for purposes of the 14th Amendment, but not state action for purposes of the 11th Amendment. Over the course of the 20th century, that line has wavered but held at the point that exceptions to 11th Amendment immunity are permitted insofar as, quote, necessary to permit federal courts to vindicate federal rights and hold state officials responsible to the supreme authority of the United States, close quote. In the last quarter of the 20th century, the 11th Amendment again emerged from obscurity as an activist federal government encountered state concern about liability, and Supreme Court justices representing different political tendencies disagreed, often forcefully, about the extent of state sovereign immunity. At one time, it appeared that the legacy of the Southern bond cases would be limited to preventing judgments against state officers that required drawing money from the state treasury. But this possibility was negatived in 1996 by the categorical holding in Seminole Tribe of Florida versus Florida, quote, the relief sought by a plaintiff suing a state is irrelevant to the question whether the suit is barred by the 11th Amendment, close quote. Seminole Tribe involved what Justice Stevens aptly called the, quote, rather curious, close quote, provision in the Indian Gaming Regulatory Act requiring states to negotiate in good faith with Indian tribes over the regulation of gambling on their reservations and authorizing the tribes to sue the states in federal court if they did not. Indian Gaming Regulatory Act, known to professionals as IGRA, and I once worked a little bit for one of these gaming companies. They determined that it be called gaming. You're never allowed to call it gambling. They went through the memo and said, you've got to take, always it must be gaming. We're in the gaming business. We're not in the gambling business. I mean, same thing to me. I didn't care. The legal issue was whether Congress could authorize such suits. The majority, this is in the Seminole Tribe's case now, the majority, in opinion by Chief Justice Rehnquist, held that it could not. Quote, the 11th Amendment prohibits Congress from making the state of Florida capable of being sued in federal court, close quote. For authority, the court relied on one of the Southern bond cases from 1890, Hands versus Louisiana, the case in which an in-state plaintiff had sued his own state. The same case in which the state attorney general had warned the court concerning the difficulty of enforcing a judgment against a state. The court in Hands had found as an historical fact that the adoption of the 11th Amendment evidenced an original understanding, broader than the literal terms of the amendment, that states were not subject to suit in federal court without their consent and dismissed the suit for want of jurisdiction. Because my focus here is on federal jurisdiction, I do not discuss consent to suit. That's a bizarre exception to the otherwise illogical federal law on 11th Amendment liability. The plaintiff tribe had sued the state's governor as a defendant, but the majority rejected this claim, inferring that jurisdiction over state officer had not been contemplated by Congress in IGRA because the legislation described a detailed remedial scheme in case a state refused to comply. Justice Souter, writing on behalf of 3 other justices, filed a long dissenting opinion, extensively reviewing the historical literature, including, I'm proud to admit, my book and a later law review article. Turning the history lesson against the majority, Souter wrote that Hands is, quote, so utterly indefensible on the merits of its legal analysis that one is forced to look elsewhere in order to understand how the court could have gone so far wrong. History, he said, provides the explanation, close quote, and pointed to, quote, the pattern of the cases which tends to show that the presence or absence of enforcement difficulties significantly influenced the path of the law in this area. The path of the law, he must have been thinking of Holmes too, Holmes' famous lecture on the path of the law. The dissenters would have limited Hans to cases brought under the constitutional grant of jurisdiction over suits involving states and citizens of another state, so-called citizen-state diversity jurisdiction. For cases against a state arising under the Constitution, under federal question jurisdiction, they would have recognized state sovereign immunity as only a matter of federal common law, waivable by congressional legislation. Seemingly irked, the Chief Justice responded that the dissent, quote, disregards our case law in favor of a theory cobbled together from law review articles and its own version of historical events, close quote. I mean, it was a book that I wrote, and a law review article, but there were law review articles and one book, all right? So it wasn't just cobbled together from law review articles, but anyway, that's an author's comment. The Chief Justice concluded, quote, "The dissent's undocumented and highly speculative extra-legal explanation of the decision in hands is a disservice to the court's traditional method of adjudication." I mean, at one time, that was pretty harsh language. We're now used to judges saying even worse things about one another. But while the Chief Justice may have a point about the explanation being extra-legal, in the sense that it was not based on what appears in the U.S. reports, and perhaps about its speculative nature, based as it is, admittedly, on the pattern of the cases, he overstates his point about the forensic use of history. The court in Hans, like the court in many other constitutional cases, purported to base its decision on its own version of historical events. As Justice Souter justly observed in reply, this court's opinions frequently make assertions of historical fact, although he qualified this observation with the recognition that these assertions are not authoritative as to history, thank God, in the same way that our interpretations of laws are authoritative as to them. Thankfully, we don't yet have an official American constitutional history. I was reminded, by the way, I wanted to just say that this reminded me of an opinion of the justices, which was issued by the, where did I put it? By the Chief Justice Appleton of Maine in 1857, responding to Dred Scott. And this is a quotation from the opinion of the justices in Maine as to whether black voters were eligible to vote in Maine. "Whatever may be the authoritative force of a decision of the Supreme Court of the United States, there can be no doubt that its statements as to the past history of this country are binding neither on the historian nor on the jurist." So they answered in the affirmative that blacks could vote in Maine, whatever Tawney said about the racism of the founders. Although the majority in Seminole tribes readily acknowledged the historical context of the adoption of the 11th Amendment, it refused to consider the historical context of the decision in Hans. Perhaps this is what the Chief Justice meant by the court's traditional method of adjudication. While it is characteristic of forensic legal history to treat historical facts as relevant to the understanding of legal documents, such as statutes or constitutions, or constitutional amendments, judges tend to treat judicial decisions as ahistorical, perhaps because to do otherwise, to emphasize the particular historical context of a decision, would detract from the appearance of judicial impartiality. Supreme Court cases are not adjudications of historical fact. Whether, as I suggested in my book, the court in Hans found its version of the past a convenient explanation for dismissing a case it could not handle for other reasons, the decision it rendered was an interpretation of the 11th Amendment, or more precisely, of Article 3 of the Constitution construed in light of the 11th Amendment. The dissenters in Seminole tribe thought Hans was wrong as a matter of constitutional construction. It is certainly plausible to argue that they found my and other historical arguments convenient as a way to marginalize a decision they disagreed with. But then it is also plausible to argue that the majority in Seminole tribe defended Hans, not only as a matter of historical accuracy in stare decisis, but also because it suited their preference for restricting the reach of federal power over the states. If, as I argued in my book, the expansive 11th Amendment decisions in the southern state bond cases were driven by fears of non-enforcement, that fear was surely absent in Seminole tribe. The federal court could safely have ordered Florida to negotiate in good faith, whatever good that would do, because there was another federal mechanism that then would take over and the Secretary of the Interior would make the decision. Because sovereign debts have come to be defined by their legal enforceability, or rather lack thereof, whether American state debts are sovereign depends on whether the creditors can secure an enforceable judgment in federal court. Obviously, the U.S. Constitution does not, by its terms, generally preclude suits against states. Quite the contrary. Instead, state suability depends, as we have seen, on exactly who is suing the state. The 11th Amendment and its associated doctrines bar the usual plaintiffs seeking to collect state debts, private investors, both domestic and foreign. That's the private sector here. To that extent, American state debts are sovereign. But the amendment et al. do not bar all suits against states, not even all suits to collect state debts. The federal government and other American states have sued debtor states in federal court and won and collected. Although states are immune from suit by most plaintiffs, their officers are not, if necessary to prevent violations of federal constitutional rights, except, it seems, for violations of the Contracts Clause. But the sovereign immunity of states, such as it is, does not extend to their political subdivisions. Here, the question is whether the governmental entity is more like a state or more like a county, a question that has proved difficult to answer with respect to some of the modern commissions and authorities that states have created. The scars of the struggle over the enforceability of state debts remain visible to this day, not only on the jurisdiction of federal courts, but also on the creditworthiness of southern states. In North Carolina, for example, the state constitution adopted in 1971 carries forward a provision that the General Assembly, quote, shall never assume or pay any bond issued between 1868 and 1870 unless payment is approved by a majority of all the qualified voters at a referendum held for that sole purpose. It's a very high standard. It's a majority of all the registered voters, all the qualified voters, not just all who vote, but all the qualified voters. Never happened, of course. Lest this embarrassment impair the state's current credit rating, the same Constitution gives the investors in later issues, bond issues, extraordinary protection. While the governor has the duty to maintain a balanced budget by making, quote, necessary economies in state expenditures, close quote, that duty is subject to the significant proviso that she must first make, quote, adequate provision for the prompt payment of the principal of and interest on bonds and notes of the state according to their terms, close quote. Modern bondholders, state bondholders, North Carolina state bondholders, in other words, are first in line in case of a revenue shortfall, ahead of school children and the indigent, probably a necessary proviso in light of the state's credit history, but one that the unreformed Ebenezer Scrooge would doubtless have applauded. And I might say, I think Die Kanzlerin Angela Merkel probably would applaud too, based on the German proposal recently floated. Thank you very much. I don't know whether that prompts questions or not, but I'm happy to try to deal with any questions that you might have.
We have some extra time if anybody does have any questions.
We have lots of time. No? Yeah. I'll call Michael. Yes.
Suppose the state of California says we shall now divide. There is no more Orange County. Mm-hmm. There will be only a yellow county and a red county. And the debts incurred by Orange County are not good against yellow county or red county. The reason I'm asking is you may have come across the same cases that I came across. Mm-hmm. This is what states did back in the 1880s about the railroad bonds. Yeah. Is there under modern rules? I mean, where do you go? What are the jurisdictional rules?
Well, I mean, first of all, it's an almost impossible. I've talked to clerks in federal court who've got judges who are wrestling with, is the Turnpike Authority or such and such more like the state or more like the county? Can it be sued? Can we get an enforceable judgment against it? And there are multiple of these authorities and agencies, and the cases go all over the lot. Usually, the sovereign test, you might say, is would the remedy, if any, recovery, if any, have to be paid out of the state treasury? If so, it's like the state, and therefore it's immune. If it would be paid, but that's an unrealistic distinction, because unless you're just going to submit the county or whatever to the obligation, and then I guess they don't go bankrupt. I mean, they just fall into state receivership or something. Anyway, the game that you're talking about is, obviously, this is an area where games have been played since the founding of the Republic. I would guess the question would be, is that just something like a move in defraud of creditors? We're just changing the label in order to try to prevent recovery. And that would then depend on the willingness of a federal court to address the issue of liability. And I think in the background has to be the question of, if we make an order, can we enforce it? the benefit of those suits by the United States government. The United States sued North Carolina on defaulted state bonds that were held in the Indian Trust Fund, for which the United States was legal title holder, trustee for the native tribes. And there was no question of jurisdiction in that case. And there was no question of recovery, because even in the 1880s, there was enough transfer of money from the federal government to the state that the federal attorneys told the court, we will just deduct the recovery from money which would otherwise be paid to the state. And we'll just keep some of that money back. We'll satisfy, it's easy to enforce these debts. Today, it seems to me, it would be very easy for the federal government to enforce debts owed by states by withholding transfers to satisfy the judgment. If the federal government would take the assignment and seek to enforce it. There was a game played in the 1880s. Bondholders in New York and New Hampshire got the complacent legislatures of those states to agree to accept assignment for purposes of collection. And they would deduct the cost of the legal services from any recovery. The United States Supreme Court denied jurisdiction, saying this is a sham. These are really suits on behalf of the foreign bondholders. The difference in South Dakota versus North Carolina was that the bondholders, by then being a little smarter, made a completed gift of some of their bonds to South Dakota for its school purposes. South Dakota then sued, North Carolina wouldn't pay, South Carolina then sued, original jurisdiction of the United States Supreme Court. The court ordered North Carolina to pay, and it did. And the court distinguished the prior case because here the state was legal and equitable owner of the bonds. The foreign bondholders then went to North Carolina and said, if you don't settle with us, we're going to keep giving these bonds away to states. They're worth nothing to us, but they're worth something to states somewhere. And so reluctantly, the state did, North Carolina settled. The fascinating development in the took place in the 1880s. Well, no, excuse me, the final decision was not rendered until 1904 or something like that. There's a nice book by Robert Durden, former professor here at Duke, about that case, South Dakota versus North Carolina. Anyway, the short answer to your question about just reshuffling the deck is I think it's going to be a matter of preference for the judges and fear of whether they think they want to get into the business of trying to enforce these debts. I mean, we've just seen what's happened in New Jersey when it's been battling over the funding of public schools in New Jersey. The Supreme Court of New Jersey finally shut the public schools down entirely. This was in the 60s, 70s, until the state agreed to impose an income tax and pay what the court thought was inadequate. And it's an unhappy history of 40 years of litigation. And we've got it in North Carolina right now with the Leandro. You're not aware of Leandro, but that's a big issue for education in North Carolina and recent orders to fund more remedial services, state orders, court orders. Excuse me. Other questions? Yes, sir. Oh, yeah, Steve.
I have, I'm very interested in the issue of sovereign immunity, sort of who counts as the state.
Right.
I adhere to what I think is decidedly a minority view in the academy, which is that Hunter and Siena was probably right and that Ex parte Young was probably wrong. But what I'm wondering is, it seems like there are some distinctions between the cases, even though they are all over the map, that might be sensible under legal doctrines of the time. So treating counties, which are sort of mere municipal corporations, different from sovereign states might not be that surprising. Treating suits against state officers who are in the process of doing something that would be tortious but for their role as an officer, namely trying to take money from you, differently from an order requiring them to do things that aren't tortious at all, unless, namely sort of, or would be tortious if they do them, namely take money out of the state treasury and pay it to you.
Unless that's pursuant to a binding contract.
Right. And so what I'm wondering is, if you got to sit down and rewrite all the bond cases, which ones do you think sort of came out right, and which tensions would you resolve in which direction?
Well, let me go back first to the county problem. Actually, as I read the cases, the Supreme Court got to its present position that counties are not states in a line of cases that go back to a John Marshall decision that a state-chartered bank was not a state instrumentality such that it could assert the 11th Amendment. Now, Marshall didn't like the 11th Amendment, I believe, and so was looking for a reason. But that was a corporation in what we might consider a more modern sense of the word corporation. That was a for-profit banking institution. But since counties were also corporations, they still are, technically. Indeed, it's interesting, the North Carolina Constitution of 1868 had an article called Corporations, which was all about local government, because they're municipal corporations. Then had another article called Corporations Not Municipal, which were business corporations. And so when that North Carolina rewrote its constitution in 1971, it just changed the name of the corporations one into local government, and then called the other one just corporations. It sorted out, brought it into conformity with our modern understanding. Now, you've raised a lot of other issues there. It is certainly true that you could distinguish between a state officer who is trying to enforce a confiscatory tax, which would destroy an enterprise like the railroad in Ex parte Young, if it paid, and should be enjoined and maybe prohibited if the statute ultimately was found to violate the federal constitution. That is distinguishable from the state officer must write a check to a welfare beneficiary because the welfare beneficiary has an entitlement under a federal statute. It's the same economic, I mean, it could have the same economic effect because either the money's coming into the state or going out of the state, it doesn't really matter. But I can see that distinction, and I'm not trying to ridicule it. I don't know. I mean, my father and my grandfather are bankers. I think everybody ought to pay their debts. If they have any money, they ought to be made to pay their debts. They borrow the money, they've got to pay it back, and it has, of course, beneficial effects on the future credit worthiness of the individual. Now, you ask another question, which I think I've lost track of in another aspect.
I'm not sure that I did ask you the adequate answer, but just so if you were rewriting the bond cases, which ones would you have written differently?
Well, I'm very sympathetic to the point I think Michael would agree that, well, I know Michael would agree, that we ought to let the states handle their own debts. I mean, there should be no bailout, because the only way to maintain the credible no bailout provision is never bail out, ever, under any circumstances. And it does lead to this terrible conundrum of enforcement. It's one thing, federal courts don't want to issue orders that they know are not going to be enforced and that there's no political possibility of enforcement, which was true, I think, in the Hans context. Souter and company came up with what I thought was a persuasive answer, and that it's a question of federal common law, not a question of federal constitutional law, and therefore it's waivable. Maybe because he cited my book, I would have voted with the dissenters in that case, but I thought that was persuasive. So, for what my personal opinion is worth, which is not much.
Yeah. So, I wanted to ask you actually on this question of federal bailouts in states. The history of federal bailouts of state governments doesn't begin in the 1840s, which came with Charles Dickens, of course, the founding of the stock market in New York, and in many ways of the Hamiltonian vision of federalism, of course, the adoption.
And the assumption of state debts in the 1790s. Yes.
So my question actually about the assumption of state debt to you as a constitutional historian is, when we talk about federal bailout of states, what is it exactly that we're talking about? I frankly just don't know enough about the assumption of whether it was an act of Congress or whether it was an executive.
It was an act of Congress. There was the 1790 Act bill. I mean, I've forgotten it as a title.
So if, as an act of Congress, then is there any mechanism outside of the act of Congress by executive decree by which a bailout could be effectuated? And the reason I'm thinking of this, of course, is the Federal Reserve's bailout of not LTCM, which actually didn't put any federal funds at risk, but of Bear Stearns, which did. And then also the bailout in 1995 of the Mexican peso, which also was unilaterally from the executive imposed from Congress. There are many in Congress that were pissed off about this, of course, but it was unquestionably an executive maneuver. So in your mind, is there any mechanism either legally or politically by which the executive can move unilaterally? And then as a separate question, which I wasn't sure if would be connected, is how does the birth of the federal system and the birth of our stock exchange and securities markets, having in the assumption of debt, effectively a state bailout, how does that inform the way that we think about some of these questions?
Like, obviously, on the latter question, there's the problem of contagion. And there's a lot of worry and thought about if one state goes bankrupt, what does that, or defaults rather, what does that do to the credit of the other states? The most recent study from the IMF, actually, working paper, showed that American lenders would continue to lend to the states they thought were creditworthy at no higher cost, even if one of those suspect states defaulted, which is odd because the terror in Europe is that if Greece defaults, then Portugal can't borrow, Ireland can't borrow, then France, Italy, then France, and the worry about contagion. And part of that's psychology of the market. Coming back to the question of bailout, I don't know. I have a hunch. This is a guess. If the federal government brought depreciated state bonds and then sued to collect them and then settled for something, I think that federal courts would have no problem. There'd be no federal jurisdictional problem. There's a lot of federal pension funds, and the Indian Trust Fund is still there, and all those entities. And I assume, and I don't know this, but I assume that an executive branch decision could be made to invest surplus federal funds in depreciated state debt. And then probably only a threat of a lawsuit would be enough to get a settlement with the state, and then these bonds would be cleared. Something like what the European Central Bank is talking about doing by transferring the bonds they bought at a discount to the, I think it's the European, EMS. What? ESM. ESM, that's what I was trying to have, yes. And then they could take the hit or whatever. The bank would not have recognized a loss on that. Yeah. European Stabilization Mechanism. That's it. Thank you, Michael. But that is a political problem. That is not a jurisdictional problem. The jurisdictional problem is asking the federal courts to issue an order in these extreme situations. And my own personal opinion is that the fear of refusal by the defendant state distorts the jurisprudence on federal jurisdiction. And that the reason the 11th Amendment jurisprudence is so bizarre, for instance, how can federal courts have jurisdiction over a suit against a consenting state if state sovereign immunity is, as the Supreme Court said in Alden v. Maine, a constitutional principle? It's the only case, and Justice Souter mentioned this in Seminole Chapter, the only case in which a defendant can confer jurisdiction on a federal court by consenting to suit which would otherwise not, in a case which would not otherwise be justiciable. And so you get this whole line of very odd doctrines which are trying to square the circle, in my opinion. I don't know, you could defer to one of the more federal jurisdictions. I see Gene Nicholas left, but yes, Bill.
If I'm not mistaken, the 11th Amendment is one of only 4 amendments that was passed to overturn a Supreme Court decision,
right.
Chisholm v. Georgia in this case.
Right.
It'd be hard to amend the Constitution, and I've never really understood what made the 11th Amendment in the same class as the 14th Amendment or the 16th Amendment or the voting age one. I can explain those, but this seems, in terms of broad political movements that are necessary to amend the Constitution, relatively arcane, though very important. What would be your explanation of how this amendment got passed?
Well, I think the one thing, it is not insignificant that in the late 18th century, the federal union had, at the time, I think 14 states, all eastern seaboard states, all represented, of course, by their state legislative appointed senators in the United States Senate, which was a body of 28 members. And I think the decision of the Supreme Court in Chisholm v. Georgia immediately triggered a response. We need to change this. And it was done within months. And it could be done. Indeed, I joked at a Supreme Court lecture that I gave that it actually, you went from proposal of the amendment to ratification in less time than it takes the ordinary federal litigant to get from federal district court to the Federal Court of Appeals, not to mention on to the Supreme Court of the United States. As the Union expands, amendment becomes harder and harder, and the sectional issues mentioned before make it virtually impossible. But also, I think we should keep in mind how narrowly written the 11th Amendment was. I mean, clearly, it doesn't say you can't sue the state to collect a debt, although they certainly knew how to say that. It says two classes of plaintiffs can't sue a state in federal court. And so I think it was very carefully tailored to address a problem which they had. I will add something else. I had the honor of speaking at the United States Supreme Court a year or two ago, and on a different aspect of the 11th Amendment. But one of the things which I talked about was, in the New Republic, what do you do if the court of last resort has reached a decision you think is wrong? Right? Now, of course, Jefferson tried to reform the court by impeaching justices like Samuel Chase, but that didn't work. You could play around with the size of the court, which was tried in 1800 and 1801. But it was rather easy to think of amending the Constitution. Keep in mind that the legal system that the framers had in mind was the English legal system, where the House of Lords was the ultimate appellate court. Indeed, until just a couple years ago, it still was, the judicial members of the House of Lords. Was it possible that the federal drafters thought, and I've seen nothing in Madison's note to suggest this, but thought we could make the United States Senate the court of last resort? And that's not as crazy as it sounds, because that's exactly what New York did at the same time. The court of last resort in New York until 1848 was the New York Senate, with the augmentation of the Chief Justice and the Chancellor. It was a political body, which was the last. And so I don't think in that context the thought of, well, we'll just rush an amendment through Congress and the state legislatures will quickly ratify it and will change the Constitution. And indeed, if you read the amendment, the judicial power shall not be construed. It's a very odd phrasing. It doesn't say shall not extend. It says shall not be construed to extend. It's phrased more like an overruling court, which says to the lower court, you've got it wrong. In the future, read the language this way. This is the authorized way. It doesn't rewrite the Constitution. It says it changes the way you're supposed to read the existing language in the Constitution. And that always struck me as somewhat more like what a court would say in reversing a lower court's mistaken construction of statute or constitution or whatever. You're reading it the wrong way. Read it this way. We're not changing the language. There was an interesting article some years ago in Constitutional Commentary, because Madison had assumed that amendments to the Constitution would be inserted into the text. And that's not as strange as it sounds. All the states except Massachusetts, to my knowledge, do that. Certainly North Carolina does. You had an amendment, you put it in, if this celebrated marriage amendment goes in, it will go in the miscellaneous article at the end of the Constitution, with Raleigh as the state capital and stuff like that. But you've got to put it somewhere. You don't just put it at the end, you put it in the text. And the difficulty of trying to figure out what you would have done with the Bill of Rights is, where do you put these things? And then it gets very complicated with the 11th Amendment, because you can't just stick it in to Article 3 because it's an instruction as to how to construe. It's not a change of the language. So you would have to, I guess, understand it as actually changing the language. If they'd done that, consent to suit, it seems to me, would be impossible, because then it would say the judicial power of the United States shall not extend to suits against a state. That's it. And, and the parties cannot give the court jurisdiction any more than an act of Congress can give court jurisdiction over an area precluded by the Constitution. See Marbury v. Madison. So anyway, that's a thought, or more than one, on your question.
Well, I think we'll have to end on those thoughts
okay.
and on that question. Thank you very much.
Yes.
And
Produced by Duke University. Online at duke.edu.